كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to lesson 7. Today we move on to the different criteria required of the witness, what kind of a witness it needs to be, what kind of moral uprightness and standing they must have. We spoke about that in the brief overview at the beginning. So he says, وَلَا بُدَّ مِنْ ذَلِكَ كُلِّهِ مِنَ الْعَدَالَةِ. All of these witnesses, they have to have adala. Adala, because Allah subhanahu wa ta'ala says, مِمَّنْ تَرْضَوْنَ مِنَ الشُّهَدَاءِ, among those that you are satisfied as witnesses. And Allah subhanahu wa ta'ala also says, وَأَشْهِدُوا ذَوَيْ عَدْلٍ مِّنْكُمْ, and bring to witness, right, to among you who are upright, who have adl, right? So adl is very, very important. Because to be upright is, because remember with the witnesses, what we're doing is we're contributing to the veracity of the case. So you need these witnesses to be upright and reliable, right? So reliability is very, very important. So that's why that is going to assist in determining the truth of the matter, because that's ultimately what the whole process is for, is to determine the truth and provide justice. So that means that it can't be somebody who's fasiq. Fasiq means an open transgressor in faith, right? Who openly does transgression. Imam Abu Yusuf has a slightly different take on that. He says that if it is a person who does certain misdeeds, right, but if he is seen as being decent among people, that while he does a few things, but he's still seen as a reliable, decent individual, a person of chivalry and decency, then we could in cases accept his shahada and his witnesses as well, because the assumption is that he would not be bought off, he would not be paid off for, some false witnessing, because while he has some particular issues in a particular aspect of his, in this kind of an issue, he would be quite sincere and genuine, right? And because of his social standing, otherwise he would be he would be decent in that regard and would be careful in that regard. Okay, so as you can see, there's some discussion there. However, the first opinion, which is Imam Abu Hanifa's opinion, is the stronger opinion, that we don't want to take Fasiq's opinion, right, as far as possible anyway. So that's what this lesson is going to be about, along with some other things. Now, along with being upright, it's also important that the testimony is provided using particular words. Even in modern law, they have to say it in particular words. There's a particular phraseology that has to be used. That's why Imam Quduri says, وَلَفْظِ الشَّهَادَةِ. Many of our revealed texts refer to that it has to be said in a particular way. And saying in that particular way, it formalizes it, makes it sound more serious, makes it more serious actually. And then people take that more seriously, and thus if they take it more seriously, then that means they're more likely to tell the truth and to do it properly. So the word is ashhadu. They have to say, I testify. The word shahada, ashhadu, I testify, I bear witness. It's like an oath taking almost. Right? It's like taking an oath, because there's consequence to saying this wrong. If a person just makes a statement without saying it with ashhadu, then it's not going to have the same ramifications as saying it with ashhadu. Okay? فَإِن لَمْ يَذْكُرِ الشَّاهِدُ لَفْظَ الشَّهَادَةِ. If he doesn't use the word shahada, وَقَالَ أَعْلَمْ أو أَتَيَقَّنْ, I know, or I am convinced, even though that sounds very strong, that I'm convinced, I'm certain, لم تقبل شهادته. His testimony will not be accepted. He has to say ashhadu. So in any shahada, you have to use the word shahada. So, when somebody becomes Muslim, they could just say La ilaha illallah Muhammadur Rasulullah because they're not in front of a judge or anything. But we usually make them say Ashhadu to make it more that I testify that there is no God except Allah, rather than them just making a statement, there is no God except Allah and Muhammad is Allah's messenger. Because when they say that, it's not really personalized. It's just a statement that they're regurgitating or repeating. When they say, I bear witness or I testify that there is no God except Allah and Muhammad is Allah's messenger, then it's like they've personalized it, they've mentioned it for themselves. Okay, so now let's get back to the adala aspect. He brings that bit in the middle regarding what wording they're going to use. I think that relates to the fact of being reliable and putting that up. But Imam Abu Hanifa, he says, يَقْتَصِرُ الْحَاكِمْ عَلَى ظَاهِرِ عَدَالَتِهِ. Now, how much do you have to investigate if somebody's upright, if he does anything, etc., etc.? Saying Imam Abu Hanifa, according to Imam Abu Hanifa, he says that the hakim, the judge, he can just rely on the apparent uprightness of an individual. He doesn't have to do an investigation to ensure it. The guy might be doing something here and there that most people don't know about, right? And that's fine, as long as he's a Muslim, right? So this is Adalat al-Muslim, Zahiru Adalat al-Muslim. He's a Muslim, he's a decent guy, he does his stuff, he's not known to do any major sins, and so on. So that's enough. Now, the only reason then, or the only case in which he will then have to fully investigate and make an assessment and an appraisal and validate this particular individual to see his reliability is if the opponent in the case, right, the defendant essentially, because remember, witnesses are produced on behalf of the claimants. So if the defendants, for example, say, no, we don't trust this guy, he's got this problem or that problem, then in that case the judge is forced then and compelled to go and investigate. The Prophet ﷺ said, Al-Muslimuna udulun ba'duhum ala ba'din. Muslims are considered to be upright for one another, illa mahdudan fi qadhfin, except the one who has been slandered, except the one who has been penalized for slandering somebody, and the slander here is something they could not back up. So if somebody slandered a woman for zina and they could not back it up with the full 4 witnesses and so on, they themselves would become incriminated as accusers, and وَلَا تُقْبَلْ لَهُمْ شَهَادَةً أَبَدًا, their witnessing will never be able to be accepted because they drop in that regard. And the apparent nature of a Muslim is that he would avoid things which are seen as blameworthy in his faith. So there's kifaya, there's sufficiency in going by that, unless somebody pokes holes there, meaning the opponent pokes holes there. Right, this is in general cases. However, when it comes to hudud, right, and qisas, as we said, those are more serious because there you're punishing somebody, physically punishing somebody with strict punishments, you're taking a limb, you're making them pay a huge ransom, etc. So illa fil hudud wal qisas, in that case, فَإِنَّهُ يَسْأَلَ عَنِ الشُّهُودِ, he has to ask and he has to make some inquiry regarding the witnesses, even if the opponent in that case does not criticize them at all. Why? Because remember, the Prophet ﷺ, he said, فَضْرَعُ الْحُدُودِ بِالشُّبُهَاتِ, try to minimize and try to repel these extreme penalties with any kind of doubt, essentially encouraging that if you can find doubt, then repel it, right? So if there's only 2 witnesses to a particular case of, for example, drinking, okay, investigate them. Anything you find about them that will drop them from being proper witnesses, that means that the case will be dropped. That means this person will not be flogged. He can just make tawbah instead. So essentially, لأنه يحتال لإسقاطها, because effort is made to try to drop these punishments, these penalties. So فيشترط الاستقصاء فيها لأن الشبهة فيها دارية, right? So it's a condition to try to go to the extreme to make sure everything is 100% and there's no doubt in it at all, because any kind of doubt created in there would repel and would drop the case. Okay, remember, this is not a case between 2 people of you owe me this much money. In those you have to try to establish that, right, to establish the fairness with that. But this is about the things that doesn't harm anybody else usually. Okay, وَإِن طَعَنَ الْخَصْمُ فِيهِمْ سَأَلَ عَنْهُمْ. So if the opponent, your adversaries in that dispute, do provide any kind of criticism, right, then the qadi has to ask and inquire regarding these witnesses, right? Because one is he's seeing what he's seeing, but then the opponent is saying, no, we know them to have this issue and that issue, so he needs to find out how bad is that issue, if it is even valid, if it is even accurate or not, or they're just trying to cause problems and poke holes and so on. Now, it says that if the judge knows them from before to be decent individuals, and he sees that the other side is just trying to cause a delay or problems, then he doesn't have to inquire about them. He can just allow them to be used, right? He can authorize them. Imam Yusuf and Muhammad, they have a slightly different view. He says that the qadi must make inquiries, that he can't take anybody at face value. Remember, that was Imam Abu Hanifa's view that we've just been covering until now. The Sahibain, their view is that for anything he has to make some inquiries. He can't just go by what they seem apparently, right? So he has to ask about what they do, not necessarily hire an investigator like that, but definitely get some idea about them, what they do openly and what they do in secret. And this is whether the opponent criticizes them and asks for this or not, right? So he's saying that reason is that you need shahadatul adl, you need witnesses that are just. So you need just witnesses. So for that you have to verify and ascertain them to be just, and you can't just take it for granted, right? So yeah. Then he says, قال في الهداية وقيل هذا اختلاف عصر وزمان. This is what Imam Maidani is saying, that this is not necessary, it looks like because they were slightly later after Imam Abu Hanifa, it looks like people had kind of messed up around that time and you couldn't trust everybody. So that's why they said that it's necessary, whereas Imam Abu Hanifa was in a more trusted time. You could just go by the reliability. So really, that's what the reason is. That's why he's saying that the fatwa is on the Sahibain's view, right, in this time. And this is Sahibul Hidayah is talking about this 500-600 years ago. And similar is mentioned in the Jawahir, Sharhul Isbijabi, Sharhul Zahidi, and Yanabir. Sadr Shahid in his Fatawa al-Kubra, and he says that the fatwa today is on Sahibain's view, and similar is mentioned in the Sharhul Manzuma of Sadidi, Haqa'iq, Qadi Khan, Mukhtarat al-Nawazil, Ikhtiyar, Burhani, Sadr Sharia, and the rest of the discussion you can find in Qasim al-Qudluba's Tashih. In the Hidayah it says that the person who's verifying, so the judge can do this himself or he can have a set of investigators in this regard, they have to also show that the person is a free man and not a slave, because slaves witnessing is not acceptable, and a slave might appear and the qadi might not know that he's a slave. But others say that that's not necessary to say that, because it was known in those days. Nowadays I guess there's no slave, so it would not be a requirement anyway. Right, let's move on to the types of cases that a witness will provide testimony in, right? Some are those things which are very straightforward. They are the primary witness in that regard. They're not secondary witnesses in the sense that they have heard somebody else testify. So what you could have is the person who has observed or heard or witnessed something directly, him testifying. That's enough for them to testify themselves, and that will be established directly. However, the other cases where, let's just say that I heard somebody else testify to something, right? And now that person is not available, so I testify that I heard that person, I saw that person testifying to something, right? So there are those two categories. Let's take the direct testimonies themselves. So he says, وَمَا يَتَحَمَّلُهُ الشَّاهِدُ عَلَى ضَرْبَيْنِ, that whatever a witness could witness to is of two categories. أحدها or أحدهما ما يثبت حكمه بنفسه. The first is the one whose judgment will be established by itself. وذلك مثل البيع والإقرار والغصب والقتل وحكم الحاكم ونحو ذلك مما يسمع يرى. This is all of those things which can be directly witnessed, heard, seen, like a sale transaction, or somebody's confession to something, I heard him confess something, or somebody usurped something and I saw that this was actually his and he usurped it and didn't give it back, he appropriated it from him, or he killed, he murdered somebody, or the judge gave a judgment and I heard that judgment, and there's another case now that requires that somebody to witness that because it's another court, for example. So in all of these cases, فَإِذَا سَمِعَ ذَلِكَ الشَّاهِدُ, when this particular person who's going to be the witness, right, if he hears or observes these things, so the thing he hears must be those things that can be heard, and see things, it must be things that can be observed and seen, right? For example, bay' and iqrar, a confession is usually heard, a transaction is usually heard and seen, right? Or something that he can only see, right? Like for example, see somebody usurp somebody's wealth, take somebody's wealth, right? Or kill somebody. You don't have to hear that, but you can definitely see that, right? So now he has the right and he has the scope, you could say, to go and bear witness to these things because he saw them or observed them, somehow heard them. وَإِن لَمْ يُشْهَدْ عَلَيْهِ, even if he has not been forced and compelled to come to bear witness to this, he's allowed to go and do this, right? Because whatever he knows is self-obligating in a sense. It entails that it in itself is incriminating. So that's why he can go and go and give witness to this. He would go and then say, "Ashhadu annahu ba'a." I testify that he did sell, he did this sale transaction. He won't say ashhadani. He can't say that. He can't say that he's making me a witness. Essentially saying that how would you articulate your shahada? If you've seen something yourself directly, you've not been forced to be a witness to it, but you have witnessed it yourself. You can just go and say, I saw it. I bear witness that I saw this. I bear witness that I heard this. I testify that I saw this. You don't have to say, he has made me a witness to this, because that's wrong. He has not made you a witness to that. That would be incorrect. That would be false actually, because he's not made you a witness to it. Meaning the person you saw. It's just being a bit pedantic, I think. I mean, it's quite straightforward that you just say, I testify that I saw this, rather than what I saw made me a witness to this. You just don't say it that way. For example, if you had heard something going on, a nikah, for example, behind a veil, in another room, behind the door, you couldn't say that I witnessed it. I mean, you could say that I heard it from behind the door, but then that will probably not be accepted because you may have heard somebody that sounds like them, right? Even if you explain yourself that, oh, I heard it behind and so on, the Qadi can't accept that because voices can be very similar to one another. They could have played a recording. They could have created it by AI right now. So how can you say, yes, I heard her say yes to him, she accepted the marriage? Well, they may have played something, they may have recreated a voice using AI. You didn't know that. Unless it's a very specific scenario where you saw that particular husband and wife, that particular man and woman, or those two individuals go into that one corner of the room and it's veiled, and you know that there's no other way for anybody else to be there or for them to leave, for example, otherwise they would have had to pass you, right? So you know 100% that there can't be anything else. They didn't have any recorders or any speakers or any phone or anything with them, for example, right? Although that's not necessary. And then you heard them say something, confess something, do a nikah or whatever, then that would be fine, because there's no doubt in that regard. It's quite clear what the case is. Okay, the second category is where it can't be established by itself. The hukm, the ruling can't be established. It's like, for example, when you didn't witness something yourself, but you witnessed somebody giving witness to someone else. So yes, I was there to hear his witness. He said he did it. He testified that he did this. Because those are not self-entailing, right? They're not necessary in that case. Because him bearing witness there outside of court. So you heard somebody testifying, not necessarily in a court, but in front of somebody else. That's not incriminating, because that's not in a proper setup of a court. That's just in front of a third person. So you're saying, well, I testified that I heard him testify in front of his father or in front of these guys or whatever, a non-court situation. Now that was the testification that you heard was not obligating in itself, right? You have to now take that to court to make it obligating, to make it formalized, right? So you are literally like the wakil, you're literally like the agent for them, you're representing them, you're their deputy. So if a person hears a witness testifying to something, a person can't just go and testify to this unless that particular witness who you heard, so let's just say person A testified to something in front of some people and you heard it. You're not allowed to go and take this to court, and that can't be accepted unless on that guy's behalf to incriminate him as his witness, or not incriminate him rather, but to use him as a witness, right? That I am representing him as his witness. So let's just say that a nikah took place and there's a witness who saw it, so he testified in front of some other people that yes, those guys, I saw them getting married. Okay, that guy can't come to court, so you heard him give that witness elsewhere, so you go to court and you provide a witness. You can't. The only way you can do that is if he makes you his representative. So you can't go and give that witness unless he makes you his representative. إِلَّا أَن يُشْهِدَهُ, unless he, the person whose testimony you heard, has made you has made you the representative, right, and told you to go to court to do that. So essentially it's a case of becoming an agent, when it's valid to become an agent or not. Just because you heard it doesn't mean that you can now say on his behalf I testify because I heard him say that. Even though you may have heard him say that, it's not sufficient, because that's not going to be enough. He has to make you his representative for that to count and for that to be valid. Similar is the case, he says, لو سمعه يشهد الشاهد على شهادته. Similar is the case if person A has heard person B make another witness and make him a witness on his witness. So that person who had given witness in front of some random guys, for example, if he made somebody else a witness and I heard that, I can't go and become witness in place of him. I can't become his representative because he hasn't made me his representative. Okay, what about if I've seen somebody's writing, right? وَلَا يَحِلُّ لِلشَّاهِدِ إِذَا رَأَ خَطًّا وَيَشْهَدَ إِلَّا أَن يَذْكُرَ الشَّهَادَةَ, right? So again, the same thing is if I've seen somebody write something in testimony, I can't go and take that, right? Unless I've been made witness to that. So it's a similar kind of case in that as well. Bismillah. So now we move on to the next section, which is man tuqbal shahadatuhu wa man la tuqbal. So aside from the male and female discussion we already had about whose testimony is accepted and whose is not, this is talking about specific categories of people. So he says wala tuqbal shahadatul a'ma. A blind person's testimony is not going to be accepted, right? Because in many cases it requires for the person, the perpetrator, to be seen and observed, and the blind person can't see, right? And they may not be able to recognize different people who are involved in the particular case. So that's why وَلَا تُقْبَلْ شَهَادَةُ الْأَعْمَى, he says, because it requires that kind of discrimination and distinction to be made, and a blind person would probably not be able to make it. Then walal mamluk, slaves aren't allowed to do it either for their owners. This is talking about now cases of this also will include cases of conflicts of interest. So slaves can't do it for anybody, nor for their master, nor for anybody else. Reason is that a witness or witnessing is a kind of an authority, right? A slave doesn't have authority even of himself. It's his master's authority. So how can he provide that kind of authoritative statement for anybody else? Right, the third person is وَلَا الْمَحْدُودِ فِي قَذْفٍ وَإِن تَابَ. I alluded to this in the last lesson, that as Allah subhanahu wa ta'ala mentions in the Quran, that the person who slanders a woman and then does not, فَإِن لَمْ يَأْتُوا بِأَرْبَعَةِ شُهَدَاء, then they don't bring 4 witnesses, then they get flogged and they become forever dropped from ever being able to give witness. Their social standing drops in that regard because they have slandered somebody. It's something that we don't ever want to happen. So that's why that's what they do, and they don't even accept their tawbah afterwards, as Allah subhanahu wa ta'ala mentions in the Quran. So Allah subhanahu wa ta'ala, so this person never being able to testify is actually established from the Quran, and there is a difference of opinion in this regard with the Shafi'is. The Shafi'is allow if they've made tawbah, but we say that وَأُولَٰئِكَ هُمُ الْفَاسِقُونَ, that إِلَّا الَّذِينَ تَابُوا only refers to the fact that they're not fasiqs anymore, but they essentially, we're saying that there's 2 things going to happen. This person is a fasiq, rendered a transgressor, and number 2, his witnessing will never be allowed again. So where Allah subhanahu wa ta'ala talks about him being, unless they make tawbah, unless they repent, that repentance is to do with the fact that they no longer will be fasiq and transgressors. They'll be they won't be sinful anymore, right? Their sin will drop. However, the punishment of not ever being accepted for testimony, that will never drop. The Hanafis take that forever. So that person can never provide proof and evidence or provide a witness in court, right? Okay, وَلَا شَهَادَةُ الْوَالِدِ. Now these are now going into conflicts of interest. وَلَا شَهَادَةُ الْوَالِدِ لِوَلَدِهِ وَوَلَدِ وَلَدِهِ. So a father or any person essentially cannot testify in favor of his children, any of his children or grandchildren and thereafter. So you can't testify for any of your direct descendants. Likewise, you can't, the next one, وَلَا شَهَادَةُ الْوَلَدِ وَإِنْ سَفَرَ لِأَبَوَيْهِ وَأَجْدَادِهِ. A person cannot testify for their parents or their grandparents and great-great-grandparents and above. Why? Because usually the benefits, there's a conflict of interest, because usually assets are kind of co-owned, or there's a certain overlap, or there's a certain benefit they can take from one another. So this would be a conflict of interest in that regard. That's why it's just completely not allowed. You have to bring other people to testify to a case of this nature. You can't bring the parents or the children or grandchildren, etc. وَلَا تُقْبَلْ شَهَادَةُ أَحَدِ الزَّوْجَيْنِ الْآخَرِ. Likewise, husband can't testify in favor of the wife, wife can't testify in favor of the husband, because again, everything related to them is too closely attached and they benefit from one another's assets and so on. Likewise, a master can't testify for something related to his to the benefit of his slave, because again, everything that his slave and everything they own, the slave and everything they own, is the master's anyway. Okay, what happens if there's partners, like 2 partners own a business, they own an asset, and the other partner has a case and requires witness? Can partner B, for example, testify in favor of partner A? Well, the case here is that if it's related to their common assets, then no, because that's clearly a conflict of interest. But if it's related to something else that's got nothing to do with their common interest, right, it's something to do with his family or whatever the case is, right, it might sound like a conflict of interest, but that shouldn't be a problem. He says, وَلَا شَهَادَةُ الشَّرِيكِ لِشَرِيكِهِ فِيمَا هُوَ مِنْ شَرِيكَتِهِمَا. So there can't be any testimony from a partner in favor of his partner in anything to do with their partnership, right? لأنها شهادة لنفسه من وجه, because ultimately it's a conflict of interest. It's like you're bearing witness for yourself, right? ولو شهد بما ليس من شريكتهما تقبل لانتفاء التهمة. Yes, if it's to do with anything besides their common asset or common interest, then it can be accepted, right? I don't know if in the modern context this would be accepted or not. I haven't checked modern law for this. Okay, now going on to other relatives. تقبل شهادة الرجل لأخيه وعمه. It's fine to give shahada in favor of your uncle or your brother. Your brother's or uncle, that's coming. So you can't give shahada in favor of anybody up or down, or your husband and wife, that's so close. But you can give shahada for somebody to the right and left, which is your brother or sister, or diagonally up, which means your uncles or aunts. So that would also probably refer to nephews then, which is diagonally down, right? وَلَا تُقْبَلْ شَهَادَةُ مُخَنَّثٍ. Any person who's like a cross-dresser, a transvestite, their shahada will not be accepted either, because they're considered to be openly transgressing, right? So they are a fasik openly. Now, if there's somebody else who just is a bit effeminate by nature, but is not a cross-dresser, they're male, but they just sound effeminate by nature, right? They just have like a very soft voice or whatever, there's no problem with them, because they're not trying to act like a man. That's just their natural state of the way that they are. Likewise, any other kind of vocation which is considered to be not a good vocation, right? So the classical problematic ones were the na'iha, the professional mourner, the one who would go and shriek and cry and make a big deal, when somebody dies, because they would hire people to do that. It just meant that you were fulfilling the right of the deceased to mourn them in that way. Likewise, a singer, right? A singer here means singing main. If there's a woman who sings nasheeds for women only, right? Halal nasheeds for women, that would be exempt from this. What they're talking about here as mughanniya is the person who sings publicly in front of men and women, right? Or sings lewd things, pop stars, those kind of things. Theirs will not be accepted. I mean, even though they're considered today very honored and they have the largest following and so on, but they're considered to be saqitul adala, right? Wala mudmini shurbi. Likewise, somebody who is given to drinking a lot, right? Somebody who's an alcoholic, essentially, somebody who drinks a lot, who drinks ala lahwi, just likes drinking, right, for the sake of entertainment and amusement and so on, because again, this person is fasik, right? Wala man yal'abu bit-tuyur. Now again, we can have many modern parallels to this, but this is talking about somebody who is usually playing with birds. His hobby is birds. Now, what's the issue with hobbies with birds? So this was essentially that if you're too much into your birds, then you're going to be distracted from doing any solid work and your responsibilities and salat and other things. So it's talking about that kind of a person. Also, number two, they had a particular scenario, right, especially in those days, which was that they kept their birds on top of their roofs. And it was a very private culture. Anybody who got onto their roof, it would be frowned upon, because then you could see into the neighbors' yards, and that's where the women would be. That would be the place that they would have their privacy, right? So this was seen as something really bad for people to keep birds on top of their roof so that they could see others. So these people were considered to be not upright at all. They were considered to be lowly people who would do this kind of stuff. Conclude this session. I mean, anybody else who has similar vocations today, your singers and people who do crazy things online, people who make haram movies, people who promote different haram kind of businesses. And then he says, وَلَا مَنْ يُغَنِّي لِلنَّاسِ. Again, this is a male singer. So same kind of thing here. If it's a nasheed artist that does decent nasheeds and doesn't go into places where they're getting all the women all riled up and everything like that and causing a lot of chaos, then they would be, the decent ones, they will be fine. Otherwise, if there's somebody who does this in mixed crowds and who would do this in in a non-decent way, right, then that would be problematic. That's what they say. وَأَمَّا مَنْ يُغَنِّي لِنَفْسِهِ. If there's somebody who just sings for themselves, لِدَفْعِ وَحْشَةٍ, to get rid of boredom or feeling lonely, then there's nothing wrong with that. So it's not about singing itself. There are halal places to sing and so on. Okay, and another one is وَلَا مَنْ يَأْتِي بَابًا مِنَ الْكَبَائِرِ الَّتِي يَتَعَلَّقُ بِهَا الْحَدِّ. Anybody who commits any category of major sins that usually has a penalty associated with it, like zina, fornication, is known to commit fornication, or is a thief, then obviously these people will be fasik. They can't be admissible in court in terms of their witness. Likewise, a person who goes into the public baths, the hammam, for example, without covering his awra, without the lower garment, for example, because that's haram for people to see. So anybody who's known to do that, to go in with small trunks even, right, that they're going to lose their standing in court. Likewise, a person who openly consumes riba, charges people riba, which means usury and interest, and consumes that. It has to be somebody who does this openly. If it's somebody who does this privately, nobody knows about it, or not many people know about it, then there could be some scope to that, because he's saying Imam Maydani is saying لأن الإنسان قل ما ينجو من مباشرة العقود الفاسدة وكل ذلك ربا. That a lot of these things, a lot of invalid, or not invalid, but maybe invalid actually, or even disliked contracts, financial transactions, sometimes have problematic features. It's very difficult to avoid them all entirely and completely. So we can't incriminate everybody, but the person who openly does it, known to charge people interest and riba and so on, then that person is not going to be acceptable, right? So yeah, we end today's lesson. Inshallah, there's a number of other cases like this which are mentioned. Inshallah, we'll do them in the next lesson. Assalamu alaikum wa rahmatullahi wa barakatuh.